If you own a condo in the Philippines, there is a reasonable chance you have never met your building's governing board, never attended a general meeting, and would not know where to file a formal complaint if the ceiling caught fire, which, as it turns out, is a timely hypothetical.
Property PH has been working through exactly that territory this week. Condo governance after a fire, installment buyer protections when a developer fails, and what lot buyers can actually do when the land they have been paying for was never legally cleared for sale. Let's start with what happened at Olympic Heights and what the law says comes next. A third alarm fire broke out at Olympic Heights Tower 3 in Quezon City on June 18th. And the question the Post takes up is not what happened during the fire. It is what the law requires to happen after and who is responsible for making it happen.
The Post draws a line that most residents never think about. The fire started in a rubbish area, which is common space, and that changes the accountability frame entirely. Here's how the Post puts it. No formal record is created, no board is compelled to respond, and no regulator is notified. The complaint lives in a thread and dies there.
That is the pattern the Post is describing. Residents organize in a group chat, confirm they are not alone, and stop exactly there. Under RA 4726, the Condominium Corporation's board can compel the building administrator to produce an incident report, request the BFP's official findings, and petition for a special members meeting without waiting for the annual general meeting.
So the mechanism exists. The gap is that most owners have never heard of their board, let alone attended a meeting to put it to work.
The Post also distinguishes the property management company, a hired vendor, in this case Oceanic Realty, from the Condominium Corporation, which is the member-owned legal entity with actual authority. Escalation to DHSUD is available if the board fails to act after a written request. The tools are there. They require someone to pick them up in writing, not in a chat thread.
Which brings us to what happens when the developer itself is the one who stops picking up the phone.
Two posts address what installment buyers can do when a developer fails. One is a full guide to the Maceda law, and the other covers the specific scenario where a developer goes insolvent mid-construction. The through line is the same. The law gives buyers real options, but only if they know what those options are and move early.
The Maceda Law Guide lays out the statutory floor plainly. After 2 years of installments, a developer cannot simply declare payments forfeited. The law mandates a refund and a formal cancellation process. The Post quotes the legal basis directly. The actual cancellation of the contract shall take place after 30 days from receipt by the buyer of the notice of cancellation or the demand for rescission of the contract by a notarial act.
So an email does not satisfy that requirement. A text message does not. The Supreme Court confirmed in Philinvest Land v. Zafra Orbe that the notarial act is mandatory. Without it, the cancellation has not legally occurred.
That is the defensive side. The insolvency post is about what happens when the cranes stop moving and the developer's hotline just rings out.
That post is direct about the buyer's legal position. Signing a contract to sell made you the holder of a contractual right to become an owner, not the owner yet. When a developer enters insolvency under FRIA, the unit is part of the insolvency estate, and you are an unsecured creditor. That sounds bleak, but the Post is clear that DHSUD's regulatory authority over the project does not end when the developer becomes insolvent.
PD 957 jurisdiction is project level, not company level. The regulator stays in the picture through receivership and any eventual resolution, which means filing a DHSUD complaint is not something you do after things settle. It is something you do the moment the evidence is there.
The Post is also specific about sequencing mistakes. Stopping payments before filing a complaint hands the developer a procedural advantage. The cancellation clock starts regardless of whether the developer has already failed to deliver. The correct order is file first, then make an informed decision about payments.
And the group chat, once again, creates no regulatory record and compels no response from anyone.
The Maceda law creates the right. The paper trail, contracts, official receipts, written communications, the license to sell number, is what makes it enforceable in an insolvency proceeding.
Speaking of licenses to sell, what if there was never one to begin with?
The third post covers a scenario that is more common than the industry acknowledges. A buyer making monthly lot payments for over a year who discovers the developer has no DHSUD license to sell and the land is still classified agricultural. The post's framing is precise. A developer can be fully registered with BIR, DTI, and SEC and still be committing a PD 957 violation with every payment you make.
Checking company registration confirms the entity exists. It says nothing about whether that entity is authorized to sell a specific parcel as a subdivision project. The license to sell is project-specific, issued by DHSUD and invisible to a BIR or SEC search.
Where no LTS exists, PD 957 gives DHSUD authority to order a full refund of all payments made, a stronger remedy than the MSITA law's 50% cash surrender value floor. The post also covers the eFOI escalation path at foi.gov.ph for when DHSUD and DAR regional offices do not respond, which carries a legal response obligation that agencies cannot ignore.
The paperwork you have, even informal acknowledgement receipts, is admissible evidence. The time to organize it is before the developer knows a complaint is coming.
The thread across all of this is the same. The legal framework exists, the enforcement mechanisms are real, and the gap is almost always information. Residents who do not know their board has authority, buyers who do not know their refund is statutory, lot purchasers who did not know to check the license to sell.
Awareness turns out to be load-bearing. Next time, we will see what else is sitting in the gap between what the law provides and what buyers actually know to ask for.